Hi, friends. The recent conviction of a high profile politician and a court clerk in the evidence tampering case in Nedumangad court has sent shock waves throughout Kerala. While the media focus on the high profile politician, as a curious observer and citizen, I am fascinated by a different figure, the registry of the court headed by its Sheristadar. Every court is made up of a judiciary and a registry. A practicing counsel is an officer of the court who belongs more to the judiciary part of the court rather than the registry part. Such an officer, a counsel, is never expected to cheat or manipulate the court. Today, studying the said judgment, I try to explore why the registry is a significant part of our judicial system and how their caution prevents the administration of justice from being hijacked by fraud or abuse of court's process. The Sheristadar as the chief custodian. In the Nedumangad case, the prosecution succeeded because the registry records were meticulously maintained intact. Even decades after tampering of evidence was committed and later revealed, no cover-up exercise was done by anyone in the registry. The tampered evidence did not go missing. Sheristadar is the chief ministerial officer of a court. Under the Kerala court rules, registry is the custodian of court seal and records. They verify every drafted warrant, drafted order form, for example, an attachment order form, etc., and evidence materials or papers taken in or out of the court, and they verify witness identity too, inevitably. If a registry officer fails to check the state of an evidence resubmitted or fails to check whether or not any draft of filled up warrant or order form with respect to the judge's actual order, they are not just making a clerical error, they are potentially opening the door for criminal conspiracy, as we saw in the punishment of the clerk in the Nedumangad case under section 120b, 420, 201, 193, 217, read with 34 of IPC, equivalent to section 63, 424 to 2209 of BNS and section 215 BNSs. The most important lesson from this case is that the Sheristadar was the complainant. When it was discovered that evidence had been tampered with, even after some notable delay, it was the Sheristadar who stood up to protect the sanctity of the court. Some argue that only a judge can initiate a complaint. However, the Nedumangad case proves that the Sheristadar, as the executive officer in charge of the records, has the statutory standing to report a cognizable fraud or forgery or abuse to the police or sometimes directly to the appropriate criminal court. This is a vital safeguard. If the registry finds in its routine preliminary inspection that a lawyer or a party has resubmitted a tampered evidence or forged draft or an unauthorized document, the registry has the power and the duty to act upon. The registry also has a duty to verify whether or not the party or counsel or agent is authorized to present papers or things or witnesses to the court. Unauthorized third party or unauthorized agents or unauthorized counsels cannot submit any evidence or draft of warrant or order form or case filing or facilitate witness entry to the court. Their signatures also must be checked and verified if available on record. The registry does not have to be silent victims of a lawyer's deception or manipulation, or a party's deception or manipulation. The Nedumangad verdict is a warning. Press report says that the state is contemplating appeal due to inadequate punishment to the convicted. The high-profile politician as well as the Registry Clerk. Bar Council may even disqualify the lawyer to practice in court for the criminal misconduct. It shows that excuses like, I did not have time to check the state of the evidence, or I didn't notice the change in the material or document is no reasonable defense when a court clerk is charged with tampering of evidence or forgery in court papers bearing court seal and court officer's signature. For a registry to remain pure, it must be fearless. It must ensure that at the verification desk, forged fillings are detected and addressed, as well as the tampered evidences. The Shadistadar is an example of how one officer's integrity can lead to the discovery of truth even after decades, while another officer's dishonesty could have caused a probable miscarriage of justice. We must support our court staff. They work relentlessly under immense pressure, even after official working hours many times. I have seen it many times. But they must also realize that they are the first line of defense against tampering or forgery. This judgment strengthens our faith in the judiciary and inevitably in its registry.